All right, next on our agenda is HB1. Mr. Chairman, you want to go ahead and present that to us?
Thank you, sir. HB1, to take a moment to give a little brief history. The bill was worked on for better than a year with the group that I had as a working group, including the prosecuting attorneys and several others, and we came up with a bill. Not saying everybody was supportive of it, but we came up with the bill. And that bill started last session and was heard in this committee. Came out of the committee, went to rules and freedom of opposition from some law enforcement agencies, and the decision was made with the Speaker himself, basically to hold up further consideration. The Speaker wanted to put together a working group and have that group study HB1. And during this past time between last session and the beginning of this session, we had a committee called the Ralston Committee, which was made up of a number of legislators, including Representative Caldwell, Representative Kelly, I can't remember, Representative Welch, who else, and yeah, Representative Rogers on there, and I think anybody else, yes, Ms. Evans. So we had a good representation of House members, as well as we had the group of district attorneys and also prosecuting attorneys council serving with this group, and we had sheriffs meeting and serving with the group. And we went through a complete review of the bill, discussing the issues that were of concern to the groups, and I'll raise a couple of them just because we did have some, what I felt, substantial change based on the dialogue and understanding that we were trying to reach. We had previously set a higher standard of what we call the clear and convincing evidence before there could occur a forfeiture of property. This was my suggestion, and my suggestion based upon, I felt it was a very drastic act of the government when it takes property after being seized and goes through a forfeiture, and I felt there was appropriate need to have that standard higher than just the preponderance of evidence. Through the discussion of the committee, I saw the reason why, from a prosecuting attorney's standpoint, that they felt the need had to be there because you do have, and this is going, let me back up and say, this is going to set up a whole new civil chapter under the Civil Practice Act, Chapter 16. We're setting out a civil procedure, and of course most civil actions are based upon a preponderance of the evidence. It also had concerns from the district attorney's standpoint because of the fact that you may have someone who is using a third party to hold ownership of property that's being used in criminal conduct, and so the difficulty then may be, how do we have the direct necessary proof to show this relationship and knowledge on the part of this third party property holder, whether it be an automobile or real estate or whatever it may be. And so I can understand from that standpoint. The main thing I want to be sure that we save is the fact that a person who has potential loss of their property, that if they are wanting to challenge this issue, that they're going to have an opportunity to appear before a judge, a magistrate, and set forth their belief why they consider the conduct of the state in trying to take the property in forfeiture is wrong. And let that magistrate hear the facts, the circumstances, the evidence from all sides and come to a decision. It's not a jury question, it's a question to be resolved by this magistrate sitting as a protector of the people and their property in this state, as we have set up under our governing system and our judicial system. So I felt at least comfortable enough to say, okay, we're going to allow, I would feel comfortable enough to allow that threshold to be back to the point of the preponderance of the evidence. I think the law enforcement people felt more comfortable, of course, with that, and I know the DAs did. That was one major area. The other area dealt with, what was the thing about, Gary, the
25,000.
Yeah, 25,000. Again, the same concern I have was that we were having what we call non-judicial acquisition through forfeiture of property meaning that because the threshold was high at $25,000, a lot of people were not being given the chance to appear before the magistrate with their concerns, because even though they may have expressed a concern and did not follow the specific currently existing language in the law about the procedure to be followed and getting a verification signed statement with all the information specifically listed, they were thrown out of court. The district attorney, the prosecuting attorney would say, sorry guys, you just didn't follow the law, so you don't have a chance. That to me was an unfair and a disadvantage to individuals, especially people of lower monetary means, to have the opportunity again to appear before a magistrate and have this question heard and resolved by appropriate arbiter of these facts. So with that in mind, we had further discussions. There is language in the bill now that we're leaving at $25,000, but if somebody walks in the district attorney's office and says, I'm unhappy you're taking my property and it should not be seized and going through a forfeiture, the state acquired this property, the district attorney is going to take an action from that standpoint and file it with the court, and there will be an action filed where that individual receives pleadings and has an opportunity to respond to those pleadings. If the response by the party claiming interest in the property does not meet, again, the specific things that are necessary to be provided as an answer, the remedy is the district attorney will file a motion for a more definite statement, just like we do in civil actions. So the purpose is to say, okay, you didn't give me everything I needed information-wise. I'm filing a motion, and the court will then give direction to that party to give the specific necessary information required to be included with the response by the person claiming interest in the property, and a timeline will be set up for the person to make that correction and the amendment of their answer. It's just what we do in civil pleadings today. We file a case and answers come in, it doesn't meet the necessary standards of the law, we file a motion for a more definite statement, and there will be the times set up, responses made, and the matter will proceed. So I felt comfortable enough saying, okay, for non-judicial, that would be a remedy that we have in the law, and the good faith of the district attorneys is they will follow that as a means of being certain everyone has the opportunity, if they wish, to appear before the magistrate and state their position. The other difference, of course, $25,000, above $25,000, it will be automatically a court proceeding. That's the main difference. You have what we call non-judicial. They give notice. The notice, they respond to that notice. They don't do so, they can then go forward with the forfeiture. If it's above $25,000, there will automatically be a cause of action, we'll say, to have the forfeiture action proceed before the court and a magistrate. Those are two main differences. The rest of it, we've had a lot of discussion on the verbiage of it to be sure that we get to the areas we talked about as far as the accounting and making appropriate reports. You know, one of the big questions we've had in the past has come up quite often is getting the information where the public has an opportunity, if they wish, to go view records about what has happened in a office of either law enforcement or prosecuting attorneys as to funds and property received in a forfeiture. As I have stated, I believe emphasized sufficiently, once the property goes into forfeiture and is acquired by law enforcement and prosecuting attorneys, it becomes public property. And as such, like everything else we have as far as accountability, it's required that there be shown accountability as to the receipt of that property and the use of the property, whether it be currency or real estate or automobiles, whatever the case may be. If the property is sold, there's accountability of that. That then converts it from, say, an automobile to currency, and there will be showing what happened and monies received, It's just like on a ledger sheet, you have cash coming in starting the year, you have expenditures during the year, and then you have the year-end balance. That's what we're talking about, just regular ledger accounting. And so that information will be compiled by those agencies that receive either currency or property for an annual filing, which will be done as it currently is done with the Carl Vinson Institute. Is anyone here today from Carl Vinson? Thank you, thank you. I'm going to have you speak to us in a few minutes, if you would. But the Carl Vinson Institute will be the repository of all this information. They'll also be the ones to help set up the forms to be used with the assistance of law enforcement and their prosecuting attorneys. Those forms are to have certain information which is by the guidelines set out in the law incorporated into the forms. So annually the forms are prepared. I think one of the stumbling blocks we've had in the past is who actually has the responsibility to file this information. The law, although states sometimes the law enforcement or DAs, they make it. There's also language that said the local governing bodies make it. So it was not always certain with whom that responsibility rested. So we cleared that up. It will be that agency that receives the property, uses the property, spends the money. They will make the reporting to the Carl Vinson Institute, where you'll have this public record information. Mr. Chairman, I think we've had in subcommittee, I know we had a number of amendments, and I'm not sure if the full committee wants to go through those, but we could talk about them. I do have a few more amendments, believe it or not, since our meeting with the subcommittee. We've had some further review and concerns with language. I've met with the prosecuting attorneys on numerous occasions, as has Ms. Travis in my behalf. I've also met with some sheriffs. I had Sheriff McLemore and Sheriff Griffin come speak with me in my office and express some interest in language that they had, and we've incorporated, and one of these, Sheriff Griffin, is that language that we talked about. I'm going to read it out in a minute when we get to it. But we've incorporated those changes. I've tried to be as really open and accepting of concerns that any agency had. I've worked with Mr. Rotondo, who is here, and Frank's representing the Chief of Police organization. I've listened to their comments. So I've been, I think, as broad and open with anyone, including other legislators, of course, to try to come with a bill that I hopefully will see carrying forward with good public policy on this issue. I think there's I say this, one of the things I believe I'm down here to do is try and protect people's property. That doesn't mean to stop taking from those criminal elements who have property acquired wrongfully and have taken cash or currency and bought property wrongfully with their fruits of their crimes. That needs to be removed from them. But we do want to be sure that the Constitution and the laws of the state are there to protect those who feel innocent in these opportunities that are given, we'll say, to law enforcement and to prosecuting attorneys to take back property that was ill-gained. So, Mr. Chairman, I'm prepared to go forward whatever direction you wish me to take with a review of HB 1, but that is the general spirit of what is the purpose behind the bill.